Hello, hello, hello. We are live. It is Tuesday. It's time for another session of Asked and Answered Live. That's Entertainment Law, Asked and Answered. We're live. It's Tuesday night. We're doing this, at least for the near future, every Tuesday evening, where I answer your questions. So I'm answering your questions live here on YouTube, Facebook, and LinkedIn. If you have a question about entertainment law, about the legal stuff related to film and television and podcasting and copyrights and trademarks and contract deals in the entertainment industry and all those kinds of things, that's what I'm here to do tonight, and I would love to hear from you. I'm gonna vamp a little bit here because we're waiting for people to arrive on the call, and I'm gonna get my windows situated and opened up on the screen. Looks like I have my friend whose name I'm forgetting again, Certain Exposures. Hey, Gordon. Where's this from? I want to do a few photo book reviews. I haven't been able to get a reply or permission to show a few I enjoy. Could I show the full cover and a blurred page or two without relying on fair use? Well, without relying on fair use. No, I think that fair use is what you're relying on. Is that, by showing the cover, you're just telling people what it is you're talking about, the object, the thing that you're talking about. And that doing that is a fair use because you're not replacing the chance for someone to purchase the thing and the need for someone to purchase it, to consume it or enjoy it. You are giving a commentary and a criticism and a review. And I think that is a perfectly good example of what would probably be fair use. We can never say for certain because it's a case-by-case analysis. But I think showing, holding up the cover of the book that you're reviewing, I think that is certainly the kind of thing that would pass muster for this kind of thing. So thank you so much for that, for being here with me today. Or, well, you're not here per se, but you posed the question, and I hope you'll appreciate the answer. So yeah, thanks for doing that. Do appreciate it. I see we've got at least one person watching live on YouTube at the moment, and that's wonderful. So if that's you and you'd like to chime in and just say hello, that would be great. Of course, if you want to give me a super chat or a tip or whatever, that would be delightful, but that's not why I'm here. So I made a note earlier of some topics and questions to be talking. Oh, I know what it was. Yeah. So, earlier this week, someone on Facebook, I think it was Facebook, posted a question in a group asking about orphan works. And if you don't know what an orphan work is, I'm going to tell you here. I'm going to open up the notes that I made from that conversation a couple of days ago. Let me see if I can find that. Yeah, because I did a little research and I made some notes. So, what is an orphan work, and what's the issue? So, here in the U.S., because we have this copyright registration system, it is supposed to make it easy to track down the authors and therefore the owners of a copyrighted work. But an orphan work is a copyrighted work in which the owner can't be located or identified. These works are still covered under copyright protection and not in the public domain. Which means that it's challenging for someone who wants to make use of those works in their creations, the researchers, libraries, content creators, because you have to get permission from the copyright owner. But if you don't know who the owner is, what do you do? And people have talked over the years about, well, I set aside some money in a special, slush fund to go to those royalty or the copyright owner if there's an issue. But the problem is that copyright law means that the owner has the right to say no and doesn't have to let you use it, just even if you're willing to pay a fee. So the key points we have to think about here is, first, it is still protected under copyright law. Copyright law lasts a very long time. Modern works, things created after 1978, or since January of 1978, are protected for the life of the author plus 70 years. So that is a quite a long time. Older works, things that were created prior to January of 1978, have a total possible protection of 95 years. So if it is less than that age, it is likely still covered by copyright law. And if you can't establish that the author of something, well, since 1978, we're just getting to the point where we're, what is that? That's all 50-something years ago, right? Almost 50 years ago. So Life of the Author plus 50, none of those works will have yet fallen in the public domain. Still under there, and that means that you need to deal with those permission requirements. So using an orphaned work without permission would be copyright infringement. And that means you're at risk. Even though the owner isn't someone you know how to find, they may find you if they see that you've infringed their work. And that could mean a lawsuit and potential money damages and so on. And if there's evidence that you knew it was copyrighted and you didn't try hard enough or you couldn't find them or whatever, well, maybe it's even a willful infringement that could lead to the higher numbers of damages and things like that. So there have been legislative efforts in the Congress to address this. In 2008, there was an Orphan Works Act that was proposed, but it didn't pass, didn't become law. And as it stands now, there isn't such a thing. So that leaves us with fair use, and it leaves us with hiring a licensing agency or firm to go and see if they can chase down the owners. And so the best practices are do a diligent search, keep detailed records, and get some legal advice if you cannot track the person, or just don't use it. So that's sort of where we are. So hello, Dory. Nice to see you watching. You say, weird question that came up today. If a person has a business in which they work with filmmakers to put together packets and submissions for festivals, NFMLA, can they get sucked into an E&O claim if they have no creative input because in an obscure way they are producing the submission to get seen? I don't think so. I think the liability is on the producer, the maker of the film. And after all, the person who's promoting the film to the festival isn't actually copying, not doing any of the things that a copyright owner has the exclusive rights to. So let me think about this. So there's no copying, reproduction, distribution, derivative work, performance, or display. That's on other parties. But the grant writer or the application packet creator, I don't think so. Now, there may be some still images and things like that that get used that could theoretically be, but they are working under a contract, as essentially a worker for the filmmaker, I would think. So there's that. Now, other kinds of E&O claims, well, there could be a defamation kind of a claim. Again, I don't think they're promoting the actual statement. I mean, I guess if they repeated the statement in their packet, then yeah, maybe. Privacy, no, I don't think there's a exposure for that person. That's a very interesting question, Dory. Dory, for those who don't know who Dory is a filmmaker herself, but also works in the insurance field, helping filmmakers and other creatives and folks get the right kinds of insurance for their projects, which can be challenging. And it's nice to have that resource. So Dory Lerner, thank you for that. Really good question. I don't think there's any exposure for that person. And, the easy solution is that when you enter into that contract with the person, indemnities going back and forth. Assisting with grant writing is, that I don't think the people who finance the film are necessarily responsible for the infringement. So I can't imagine that the person who's asking for the money from the financiers would be any more liable unless they also have a hand in the creative decision making for the film. And Dory says, "Oh, that's good because insurance premiums are getting out of control." Yes, this is true. And you know who you can blame for that? The effing lawyers. right? I mean, there wouldn't be a need for insurance at all if not for lawyers and lawsuits. So I guess I got to take my share of the blame for that. The litigations, yeah, at the hands of the lawyers who make it happen. And you know what? The damages and the liability these days is way up there, and so the premiums have gone up. I won't say that the insurance companies haven't taken an opportunity in an age of inflation to bump their rates up maybe more than really needed in order to do the kind of underwriting that they do. But, hey, business is business, I guess. Insurance companies, we can talk all year long about the merits and demerits of the insurance industry. And Dory, I'm sure you're more intimately aware of that stuff than many. So thank you. That's a great question. So the orphan works I talked about, I think. Yeah. And what else did I have on here? Any other questions? We should have lunch soon, Dory. You know what? Reach out to me. I'd love to do that. It'd be great. Let me come back. I had a couple of other notes here. Let's see. I had an interesting debate. This is a debate from a while ago that is ongoing with a colleague of mine, and he posed the question. I guess there was an ad for some kind of home improvement store. It might have been Home Depot or Lowe's, one of those, where the ad started out with a line, "Summertime and living is easy." And those who are at all familiar with the Gershwin genre of jazz music and so on, they will know that that's a line from Gershwin's Porgy and Bess opera. And the question was, is that some kind of a exposure for liability, just using that one line from the song? And he and I went back and forth around about it for a while. This is a few years ago. And he brought it up to me again today when we were on a Zoom call together and asked my opinion. And I was able to come up with exactly the same answer he said that I came up with back then. And that was that, no, I think that's a de minimis use. De minimis is a Latin phrase, but it really ties into too small of a molehill to make a mountain out of in the legal, particularly the copyright arena. It's just, we're not going to dignify such a small use with copyright liability and lawsuits and things like that. So that might be a thing. It's just not big enough to worry about. However, he reminded me that there was a case involving the I Love New York jingle that was used in an ad campaign, several ad campaigns for the city of New York tourism and so on some years ago, where someone had copied the exact same, I think it was the first three notes of that or something like that. And in that case, the court said it's the entire hook, the most important part of the work. So it doesn't matter how small, it's the most important part. And he pointed out to me, well, the summertime and the living is easy is the hook line from the song in the Porgy and Bess music opera. However, the difference is in the I Love New York scenario, it's repeated over and over and over and over and over and over again in the song. So it's, it's a very brief stanza with that phrase used over and over again. In Porgy and Bess, that line occurs exactly once in the course of the whole opera, if you look at it as one big work, or in the course of that song in the opera. It only occurs once or maybe twice in the whole thing. And because it's a lengthy work and one line, it's such a small percentage of the whole. And that gets us into a fair use conversation about whether or not that, whether it's de minimis use or not, we have to ask, well, is it fair use? If it was an ad for commercial, so the purpose and character of the infringing use, that probably weighs against a finding of fair use. But the nature of the original is a musical work. Maybe a little argument in favor of a transformation into something more commercial and modern, but not very transformed. So that weighs against. But the amount and substantiality of the portion taken weighs small. And I'm sorry, weighs in favor of fair use, I think, because it's such a small taking. And that leaves us with the fourth factor of the impact on the market for or value of the original. And this is one of the few areas where I sort of buy the notion that by bringing it up and using it that way, it actually is good for the value of the original because it refreshes the song in people's minds. Now, it's certainly not a real big detriment because to license the one line couldn't possibly command a very significant license fee. And so, yeah, I think that it's a toss-up how that comes down. Nobody ever sued over it. It was never a thing. It was just an academic discussion between two lawyer friends. And so there you go. So Dory is asking, what is the time cutoff for fair use? And I think the short answer, Dory, is there isn't one. Fair use is a defense to claims of copyright infringement, and it is based on the First Amendment, freedom of speech. If you are accused of infringing a copyright, that means that the copyright is still in force, so less than 70 years after the death, if any, of an author, or 95 years since the publication of the work if it was under the old Copyright Act. So anytime during those windows, someone could make an accusation of infringement and file a claim and sue somebody. And the defense of fair use says, hey, freedom of speech, we're going to evaluate in light of public policy. Which is it? Is it more about free speech in this case or more about protecting authors' rights? And so there's no time limit or cutoff. You can defend yourself using fair use at any time you get sued for copyright infringement. As a practical matter, the older the work is and the less that's taken from it or the more it's transformed, those are factors that would weigh in. But no, I mean, I think I could probably copy something from 1930 and because that's 94 years ago, and get sued, and I would make the fair use argument. So that's that. Thank you. That's another interesting and thoughtful question. So, what else? I've talked about the orphan works. I talked about the de minimis situation. Oh, here's another one. This is an interesting one that unfortunately there isn't really a super direct legal, well, I guess the answer is direct enough. It's just not a satisfying answer. A fellow contacted me telling me that his film that he made a few years ago keeps getting uploaded on YouTube without his consent, and that he then has to play the game of whack-a-mole and send the notice to YouTube to take it down. And he knows that YouTube has the algorithm that can identify the work by its sort of digital fingerprint and those kinds of things, but they apparently haven't effectively enabled that use of the Content ID system, that algorithm, to prevent people from uploading his film. So he says they catch some, but not all, and so on. He wanted to sue YouTube. And I started by telling him, well, I'm not the litigation attorney, so I wouldn't be doing the suing for you, but I don't think there's much of a suit there, and here's why. The Digital Millennium Copyright Act, the DMCA, is set up in such a way, very deliberately, to provide a safe harbor for companies like YouTube, Facebook, Twitter, X, call it what you want, all of these services where the users are posting content to the site. The safe harbor is such that you can't sue them if they immediately, well, within a reasonable time after receiving a properly formatted takedown notice. If they take it down and they have steps in place to deal with repeat infringers, there's a list of criteria, but essentially if they take it down and they have a system and they deal with repeat infringers, they are immune from lawsuits over the copyright infringement and other kinds of claims. So the failure to adequately prevent the uploads is probably not it's definitely not something that's actionable against the company. Now, there may be some other kinds of claims that would come in if there's some contractual promise when you upload or when you, but again, I don't think that's the scenario here. Something you could talk to a litigation attorney. There might be some other basis for it, some implied contractual stuff, or maybe something based on an unfair competition or tortious business practices kind of claims, but I don't really think there's much there. And when you go to sue one of these online companies, there's another component. The Section 230 of the Communications Decency Act also provides a broad swath of immunity to online providers for content that is posted on their sites, separate and apart from that DMCA safe harbor. So it's a really tough row to hoe to bring a case against these companies over stuff like that, even though you're absolutely right. He's the owner of the copyright in the work. It's his thing. He gets to control who posts it and so on. But right now, the way it's going is he's got to devote time and energy and resources every day, every week to stopping these infringements of his film and dealing with it if somebody does claim that their post is legitimate for some reason, like a fair use or something. So it's a terrible situation. Unfortunately, the game of whack-a-mole is the game, and that's what we're sort of stuck doing. I think there are services out there that can do the monitoring and takedowns for you, but now you're paying money to go after lost money opportunities and things like that. So it's a challenging and troubling situation. Looks like I've got some people watching. I'd love to answer other questions. If anybody's got something, drop them in the chat. You're confusing public domain. Yeah, Dory. So back to your copyright question, Dory. Yeah, fair use is as long as the work is protected and you have a lawsuit. But the public domain kicks in, or I should say, a work falls into the public domain 70 years after the author or the last author dies, if it was created after January 1st, 1978. So that's a very long time. And if it was created before January 1st of 1978, then the copyright lasts, assuming it was renewed in the 28th year, it will last up to 95 years. So that's why Mickey Mouse fell in the public domain this year, because Steamboat Willie came out in 1929, 95 years ago. So copyright duration is a fun an interesting exploration, I guess you could say. We always have to do these calculations and verify, was it renewed back then? Because if it didn't, then maybe it fell in the public domain early. That's why It's a Wonderful Life was in the public domain for such a long time and became a television sensation, is because someone didn't renew the copyright at some point. And it was recaptured under a bunch of different treaties and things like that at some point. But yeah, It's a Wonderful Life is one of the examples where registration was not renewed and it became a problem for the copyright owners. And there's a few others out there like that too. So no other questions? I don't have any others lined up for tonight, but we're going on a half hour now, so it's a reasonable show, I think. I'm going to come back again next Tuesday to do another episode of This Entertainment Law Asked and Answered. Oh, here's Bree. I do have a question, Bree. I'll come back. I'll finish. Yeah, I'll take your question. Let's see. What would you recommend for a podcast with 4 co-hosts that are all related, and now they have family arguing and one co-host wants to step aside? Should they get an agreement written up? Yes, I think they should. It may be that it's a little late for that. Unfortunately, when it's family members, you're sort of in that weird, are you going to really do contract to manage a family relationship? But you got a business together. It makes sense to get your ducks in a row. Some kind of a podcast prenup or form a company. If you're starting out, I would say that's when you want to really get these things down in writing and just get the clarity so that everybody knows if I leave, here's what happens. Assuming that the other 3 want to let the one leave and the one doesn't expect to get bought out or something like that, it should be a pretty straightforward, simple transaction. But it now is hey, look, it's no time like the present, if not in the past. So yeah, get something written up. And thanks, Bree. It's good to see you. So as I was saying, I'm going to come back on Tuesday next week for another episode of Asked and Answered. And if you have a entertainment law question that you would like to submit for me to respond to before that time, you're always welcome to come on live and do it with me. But if you'd like to send it and make sure I answer it, go on over to firemark.com/questions, and you can complete a little form and send it up. And I'll try to come back to you with the answer. So, yeah, Bree, we'll definitely connect soon. Maybe in the next few days, I can jump on a call or whatever. So, yeah, let's do that. And let's see. Dory's going to call me about another situation, so we're not going to talk about that publicly because it's real people with real problems and issues, and we're not going to out them in public. Okay, great. So head on over to firemark.com/questions. Reach out to me however you like, and I look forward to seeing you again next Tuesday when I do another episode of Entertainment Law Asked and Answered. Thanks for being with me, and I'll see you soon.